All right. Good afternoon, everyone. This is Curt
and Brad Pinsky.
And we are here for another edition of Fire Law Roundup, this time for May 8th of 2023. Brad, go ahead.
Absolutely. I'm glad to be back in the office after FDIC for a week, which I had a great time lecturing on all sorts of issues. But I always start off with, if you watch Curt and I, you will see that it's always almost about discrimination, harassment, and today will be absolutely no exception, with the exception of one first. Quick one you just added. Let's start in Nevada. Nevada, we have a firefighter who's being sued by I guess a bystander, a citizen, over an altercation. It's caught on video. I haven't seen the video, but basically what happened is this woman apparently is outside feeding stray cats. Apparently, allegedly, a male firefighter comes outside. They get in some altercation. Allegedly, I don't know, she swung at him, he swung at her.
Yeah, the video is pretty clear. The video shows her, like, it almost looked like a slap, but she reached out and either made contact or attempted to make contact. Looks like almost twice, but at least once. And then he responded, by pushing her down.
Okay. And then she's now suing, all right, for $15,000. Not a large amount, frankly.
Yeah, I think that's a jurisdictional amount. I think they allege the jurisdictional minimum for that court. So yeah. So
that's really where it is, just a suit. There's a little part, they also want an apology, but there's a little part in that there was the citizen was initially charged with assaulting the firefighter, but the charges were dropped. I'm curious what went into that. If they dropped the charges, why didn't they tie something to that? Hey, we'll drop it, but you agree not to sue, or I don't know, something you would think, or maybe they just thought that there wasn't enough to charge. But when you're assaulting a firefighter, it seems to me maybe there is. So,
well, I think maybe they felt bad for her. I think she's in her 70s, if I'm not mistaken. And I'm just noticing now the blog says that there's some sort of a restriction on the video, so you have to go to YouTube to watch it. I'll see if I can clear that up. But yeah, they initially charged her and later dropped the charges, and that's prosecutorial discretion. It doesn't mean that she didn't assault him. But the question becomes,
I don't know the law in Nevada about, do you have to back away? Do you have to not? But, let's try not to hit our citizens. I'm not saying he was wrong. I'm just saying it will save you, for 2 minutes of defense or, an action, it'll save you 3 years of problems. You might as well just see if you can walk away. Look, have her arrested if you want to have her arrested, but let's try not to, unless our lives in danger, assault our, citizens.
Yeah. No good can come from it.
Yeah. So now let's talk about discrimination. And again, if you're a longtime viewer, right, that Curt's statistics, I think, are low, frankly. It seems like all we do is talk about discrimination and harassment, but 70% of suits are discrimination and harassment. That's what I talked about at FDIC. I said, listen, I redid my whole presentation, said, we're going to start with discrimination and harassment policies because that's what's happening. We had a really nice question. So we're going to start in Baltimore City, and there's a race discrimination suit, but then we're going to move over to another court decision, which does a really nice job of talking about disparate impact and disparate claims to all those. But we're going to start with the suit. But when you hear the discussion of the decision, this one that we talk about, maybe we should do the decision first, but the one we're going to start with, Baltimore City, on race discrimination, it will kind of, some of these will make sense. But if you have not seen Curt and I talk about McDonnell Douglas, the test, we'll do a little more intricate. I'm prepared to do a little more in-depth discussion because we should every few sessions get back to it, because if you watch, you're going to constantly hear courts and Curt and I talk about the McDonnell Douglas burden shifting test. And if you're an administrator, you have got to know this. But let's start with just a suit. And we have a race discrimination suit filed in Baltimore City. This is a lieutenant with the city. He claims he was subjected to unfounded disciplinary investigations and retaliation. Now, I'm going to have a take on this where I'm going to also bring up another, our last one, I think, that we deal with. And it's this, before I get too in depth. When you, in your lawsuit, start alleging that there's a reason things are happening And then you say, but really it's because of race or something other discrimination. I don't think you're doing yourself a favor. And you'll see, here's what I'm talking about. So we have this lieutenant who claims that prior to April of 21, he had an unblemished record. He then said he had a verbal exchange. So listen, this is my point. He had a verbal exchange at an incident with on a scene with a female Baltimore County paramedic who turns out is the husband of a city fire officer. All right. And he said at that point, he became the target of race-based, quote, vengeful, false and frivolous complaints. Now, let me stop here. The fact that you are a protected class, female, black, of certain religion, whatever, it doesn't matter. The fact that you also happen to be one of a protected class does not mean, in my opinion, that everything that happens to you is because of your race, etc. Here, to me, as I read this complaint, the first thing that occurred to me is, wait a minute, you just told us why they're retaliating against you. All right, let's assume the retaliation is all true that I'm going to go through. You just gave me a non-race-based reason for the retaliation. You pissed off this woman and then her husband, who's an officer, who was retaliating against you, not because you're black or anything else, but because you went after his wife. And that's not a protected activity. So that's and you're going to see this again coming up. It seems like everyone always does this. Well, I did something and you were coming after me, and then it's also because I'm whatever, right? A protected class. It just doesn't work. In any event, so I asked the question, why is this race-based? You just told us it's retaliation-based, which is not necessarily protective. And so then he goes on with all the things he claims were race-based, right? And I'm not trying to degrade his lawsuit. I'm just saying, when you start with here's why they're doing it, and it's not based on being a protected class, I think you hurt yourself in the lawsuit. So he then says over the next 2 years, he was subjected to investigation after investigation. He then had to seek therapy for anxiety and panic attacks, which, by the way, is where he should be focusing. And then he said the hostility keeps going on. He keeps complaining about the mistreatment. He claims that white firefighters are not subjected to any of these indignities. Well, yeah, because maybe the other firefighters, forget white or black, didn't attack the fire officer's wife. In any event,
I'm not sure he attacked, but there was some sort of verbal altercation.
Not physical.
Yeah.
So he then gives a whole bunch of examples of what happened where, look, maybe he is being subjected to a lot of mistreatment, etc., but he's going to have to prove that it's because of his race and not because of anything else. Now, I will say this. He does say on May 5th of 22, he receives an anonymous text message from a number. He said it's clearly a fire department number. I don't know how he'll establish that, but we'll figure it out. But it says it has threats of violence, stalking, vandalism, and racist and disparaging remarks about plaintiff. Okay, now, once you get that involved, now maybe we do have a race issue, right? When you're attacking someone using their race, now starting on May 5th, he might have an issue. In any event, he says that he was targeted of specific harassment, like somebody put a nail in his turnout boot. That's workplace violence, etc. So that's the lawsuit. I would frankly have approached this in a different way. I think workplace violence is something, I think, causing PTSD, that they cause PTSD. Of course, lawyers don't like that because they say, well, if you got PTSD on the job, it's just workers' comp. So they don't get anything when they're suing for workers' comp. In any event, it's just a lawsuit. But I raise this because it's going to come up again when you give them a reason for the retaliation, and the retaliation has nothing to do with the protected class. Maybe you just shot yourself in the foot.
Interesting. Yeah, I didn't think of it that way, but you're right. Absolutely right.
And this is going to be a repeating thing. Okay, so let's talk about Memphis, and I'll slow down here. I broke this out. I kind of I love how you wrote it. You tracked the court, and the court did a really good job. So I did a little bit more to make this a little more clear to everybody, because again, I believe that every so often we should really go through the McDonnell-Douglas test, and this court just did a good job of it. So here we have a decision by the Sixth Circuit Federal Court of Appeals, a very smart court. Courts of appeals are, even though they're political appointees, are generally pretty accomplished judges. And they held that the Memphis Fire Department did not discriminate against a female who's African-American who sought a position, right, as a Airmask Maintenance Mechanic. She claims that a less qualified male obtained the position. Now, the facts aren't complicated, but the legal analysis is very thorough and impressive. So, and probably written just by the law clerk, because it's the same thing that's in a million other decisions, but it's good to go through. So here they say Franklin's a non-firefighter employee of the Memphis Fire Department. She alleged that she didn't get this position based on race and gender. The trial court starts by saying, we agree, there are race and gender issues. They're subtle, right? So we're not, they're kind of laying the framework to, when you see that happen, we sympathize, but you lose. You don't have to get too far in the decision to realize when the court's placating you, but they rejected it. So the facts are basically she applies for this job. The job as a scoring system, very important, good, by the way, for those who are doing promotional exams. This is a good reason why you do it this way. They asked 8 questions. They, right, as objective as you could be, scoring is subjective, but they ask 8 questions and the same 8 questions to every candidate. No follow-ups, no, let's talk about this. You ask the question, that's it. And you leave them with their answer. You don't follow up with the answer. You don't respond to anything. You leave them with the answer, right? Maybe you can add well, you didn't understand the question or something, but you just accept, here's the question, here's the answer, that's it. And then they're subjectively, of course, scored. So the subjectivity, which lawyers hate when we try to protect our clients, subjectivity leads to discretion, discretion leads to lawsuits and other reasons why you actually were subjective, but you have no choice. They had to be somewhat subjective. So they then score her. She finishes second.
Well, there's another part to what you're talking about. I've been involved in these types of things from the evaluator perspective, and the ones I've been involved in, they actually have a psychologist who's running the overall program. And what they do is they merge the scores. And so, yeah, so if you have, I think they said they had 4 evaluators. Okay. So if you have one evaluator that marks somebody as a 10 and somebody else gives them a 3, the psychologist steps right in and says, wait a minute, what's going on? And, you know, fixes that thing, because you just can't have, if somebody gives somebody a 10 and somebody else gives them a 9 and somebody else gives them an 8, that's one thing. So what happens when you do it right is you work out those types of things. And then sometimes they'll throw out the low one, throw out the high one, and average the others. There's a bunch of different ways that they do it. But it's really important, and this, I think, is a really good model for doing that, to avoid that. But you want to have someone with technical skills, not just somebody who's got a fire instructor 3 or not your lawyer. You want someone with a PhD, a psychologist who's going to set the system up and then make sure that those types of problems are out. But you can either average them, or you throw out the high, throw out the low, and go with the middle, and so on. So,
perfect. Yeah. So she was second. She finished second. A white male finished first, and those facts aren't very favorable to her. So the court goes through their analysis. So there's 2 basic claims. You have disparate treatment and disparate impact. Right. And let's look at each one of them. So disparate treatment basically says you treated me differently based on my whatever, race, gender, etc. Right. So here there's a 3-step test. So step 1, and I'm going to go through this kind of slowly, show the test, and I'll show how the court deals with it. So step 1 is the burden's on the plaintiff to establish a prima facie case of discrimination. As you always say, it's not that hard. She's Black, she's female, and she didn't get the job. So it's a very low difficulty threshold, right, to prove. So everybody almost always gets past step 1 if you're some sort of protected class. Where people lose this is I'm overweight or something like that, which things that may not be necessarily protective. Okay, step 2, the burden now goes over to the defendant, like a ping pong. All right, burden goes to the defendant, and the defendant here, the city, has to articulate a legitimate, non-discriminatory reason for the adverse employment at issue. And here is, okay, we scored them, right? And we scored based on this criteria. Race was not a factor. It was based on interview questions. So their non-discriminatory reason here is we can justify our decision. We asked questions, and she was, scored second.
Came in second. Yeah, she came in
Had
second.
nothing to do with her race, had nothing to do with her gender. The questions were the only scoring mechanism. And they probably said, if we looked at the papers, gender and race were never any method of the scoring, right? Didn't matter. Okay, step 3, then the burden goes back to the plaintiff. And this is where most cases, frankly, end up, right? On the third step. And the third step of the McDonnell-Douglas test is that the plaintiff has to establish that the reason given by the defendant in step 2 was a pretext. In other words, they're trying to cover it up. Yes, we had the scoring system, they would allege, but it was really their decision was intended to discriminate against Black, female, whatever. Now, this is not, let me be clear, what we're going to discuss next about disparate impact. There, they could argue, well, the scoring mechanism, though not intended to discriminate against females or African-American, had the impact, right? That's not this. This is an intentional discrimination.
Yeah, we'll get to that.
We'll get to that. Okay.
This is disparate treatment.
Right. And this is intent. They intend to treat you differently based on your race. Right. And that's really what I'm pointing out. This is intentional. The next one isn't. So they had to show that the reasons were false, pretextual, and they couldn't do that. Right. That's really where we get. They just couldn't do that. They said the reason the scoring was done, it was fair, and there is no way to prove it. She loses. So then the court says, okay, what about its disparate impact? And this is a practice which, okay, the practices are fair in form, but they are discriminatory in their operation, in their effect, right? Their impact. So when you don't have to show an intent, it's just that it happened to become discriminatory. The example
the best way to think about, I think, disparate impact is statistics. You have to show statistically, because you can't show intent, even indirectly. You have to show statistic that statistically, whatever criteria they're using more heavily burdens a protected class. So you've got to be able to show some way that you are burdened by this process.
And by the way, this is, I've given this example on a prior show, but I want to do it again. This is a very difficult test sometimes to show disparate impact.
Yeah.
And sometimes it's just maybe as simple as, okay, but we have 50 white percent, right? And 50 African-American, but only 2% of African-Americans ever get the job, right? So sometimes it's that easy based on stats. Sometimes it's not. The one I go to on disparate impact is on a civil service exam where they show a picture of a Halligan. And the question is, what is this tool? It took me forever to figure out, why is the court going to say it had a disparate impact? This test has to be thrown out. And the reason is because volunteers who are taking the test would know this. If you're a volunteer firefighter, would know what a Halligan is, whereas a citizen might not. Okay, you think, well, how does that have a disparate impact? Well, where are most of your volunteer fire departments? Mostly in the Caucasian, right, last minority areas, whereas most of the African Americans, Hispanic, et cetera, they would live in the city and they don't have the same chance to volunteer. That's a good example of how hard it is sometimes to show disparate impact. And that takes sometimes a PhD level person, not a lawyer, to come out and say, this is why this is unfair. So sometimes it's easy, sometimes not. Okay, so disparate impact. Hopefully everybody knows what it is. And again, you don't have to show you intended to discriminate. So 3 steps again, right? Step 1, we have a plaintiff has to identify a practice that they're challenging and has to prove through a statistical analysis, in this case, that the practice has an adverse impact on a protected group. And if the plaintiff can do that, then the burden shifts to the employer to show that the process has a manifest relationship to the employment. In other words, is a business necessity, that we need to accomplish this by this method. Now, I will say a lot of times they fail here because there's an alternate method that could have been used, which didn't have a discriminatory impact. And then it switches back that the plaintiff has to show that, here it is, other methods could be accomplished, right? And that's step 2 and 3 is usually where this goes. In any event, the court simply held, I won't say more unless you want to, that she didn't prove disparate impact. And I was surprised they pled disparate impact, because they would really have to show a pattern. And how are you going to show stats and all that with this?
Well, I think her argument, and it wasn't clear. Apparently, the court mentioned it that it wasn't clear in her complaint, but the judge treated some of her allegations as alleging disparate impact.
Okay.
But what she was saying was she's a civilian employee. Most of the civilian employees are females. Okay. The firefighters, which the person who got the job was a firefighter, most of them are males. So I think she was sort of hinting, she didn't make it clear, but hinting at there was a disparate impact when they favor firefighters over civilians for this particular promotion. Then there's a gender bias in there. But the court said that she wasn't able to really establish that to a level that would allow her to get to trial. And one 50,000 foot point that I think I want folks to take away from this is we have 2 3-part tests. Okay, the McDonnell Douglas is one for disparate treatment. The disparate impact comes from Griggs versus Duke Power Company, and that's that really disparate impact test. So again, it gets a little bit confusing, but it's important that we understand there are those 2 different tests. One's for treatment, one's for impact.
And the intent factor is really the issue, right?
Yeah.
You're not a bad person necessarily, or a bad defendant. You're not a bad anything if you have a disparate impact necessarily, because you're not trying to discriminate. It's just the effect is discriminatory. And there's a ton of those cases that hold, yes, there is a negative effect of this policy upon whoever. It's the unintended effect. Maybe it's intended sometimes, maybe it's a cover up, but usually it's an unintended effect. And people just don't think about it at the time, right? Because there is a case, I wish I could think which case this was, but the judge talks about the people who created the test were, let's say, males. They thought it from their male point of view. They didn't think about the effect of the policy or whatever on females. So it had a negative effect, but it wasn't their intent to discriminate. It was just the vantage point didn't give them the open view. And this is the point I want to make. Based on that, when you create certain tests or exams, and we're not going to do it with just ourselves, right? Bring in a professional, but any decision you make or policy you write, even a policy you write, still needs to be viewed from everybody's vantage point. Case in point, and I'm getting way off topic, but I'll stop after this. Case in point, you can't wear head coverings. Okay, can't wear head coverings because you got to put a helmet on. Well, wait a minute. You're not thinking this from the point of Orthodox Jews or Muslims, or right? You're not thinking of that, or earrings, or all sorts of things have religious implications. We're not intending to discriminate based on religion, but the impact is that it is. Okay, hopefully everybody understands that. Now, if you want to move on? Because okay, so now we have another lawsuit, and this goes back to my first claim, which is, and now think of this in part of the 3-part test if you want, but it's when you raise an issue that gives the judge, oh, that's why they're doing this. It's not because of what you're saying. When you put it right out there, you're not doing yourself any favors. You're kind of giving justification. And here we have a fire captain who was demoted. He sues California Fire, who sued like every other day, it seems. He alleges disability discrimination and retaliation. I'm just going to say that I don't think his disability claim comes until about halfway down. So here's what happens. He's working, let's see if I can sum this up. He's working for a higher ranking individual and who's in charge of purchasing, et cetera. And he keeps complaining about him, right? And he says in here, he claims he's making valid comments, right? We're not following the procurement policy, or you're just telling people to buy things, or using a credit card for an improper purpose. But he says, I'm making valid whistleblower, and he should have been saying whistleblower in here. I don't think he did. Maybe that'll be mixed into retaliation, but he claims he made these allegations. So obviously he's pissing off the person above him, right? And so bring that into my pretext. The reason maybe bad things are happening to you, and as we're going to talk about, people are celebrating your demotion and whatever, is because you complain all the time. Now, I'm not saying he's wrong about complaining. That's not what I'm saying, but it's a non-discriminatory reason. So he says in about 17 occurring through 18, he suffered from disabling conditions. including distress, anxiety, depression, PTSD. And so in 2018, he attends a mental health retreat for approximately 7 days. And then in November 20, a chief, and you got to know the name because it's going to come up here, Defendant Maine, transferred him to the Santa Clara unit, and Maine became his direct supervisor. Thereafter, he keeps, the plaintiff keeps complaining about all these violations, but including not only the accounting violations, but also safety violations. So I stop there and say, well, maybe the retaliation that's coming has nothing to do with, any of your stress or anxiety. They accommodated your stress and anxiety by moving you to a different position. And then, now things start happening. So then he says, he was then in 21 removed as a logistics officer position. Okay, there's maybe some retaliation. I don't like you complaining against me, whether it's actionable or not, it's different. Then he says, well, I've sought reasonable accommodations, including multiple transfer requests in order to stop all the harassment. So he does, but nonetheless, it goes on. All of the requests were denied. And he said, they just said you have to engage in a good faith process to try to resolve these issues. We're not just going to transfer you, which is probably good. But then he says, as a result of not being transferred and the continuing conflicts, he suffers from more symptoms of his disabilities, including PTSD, stress, anxiety. Now, part of this may be of his own doing, part of it may not be, right? Still, he's having these complaints. And then he says in 22, he learned he's being demoted from captain to firefighter 2. And mostly, he says, it's because of his false accusations of patient abandonment related to an emergency response in 21. That's allegedly why he was demoted. He claims it was retaliatory, I'll say, for being a whistleblower complaining. In any event, the safety officer determined that the allegations against the plaintiff were false, and defendants provided the complainant with back pay, and removed the suspension from his record. So they kind of do help him out a little bit, saying, okay, we agree, you shouldn't have been, accused. In any event, he's then demoted. And what happens is there's all this discussion, and there's basically a party that some people were at. Some people said, I wish I came to, and said, yay, we're celebrating his demotion. So he says, based on all of this, I'm being discriminated against because of my disability. I can stop there. I have a whole bunch of questions. It's just a lawsuit, not a decision. So you don't know how it's going to play out. One of my questions is this a workers' comp issue? In other words, if they cause him stress from being on the job, could that be a comp issue? The reason it's important as a comp issue is you can't sue. One of my other questions, you can't sue your employer for comp if you just develop stress from your job, right? The other question is maybe it should have been a FMLA claim. I think his lawyer should have been watching our FMLA series, because it sounds like maybe they could have claimed that they're retaliating against me for taking leave. If there were comments about his leave and his taking sick leave, that's FMLA retaliation. And yes, disability discrimination, but it sounds more like retaliation. By the way, I think retaliation is easier to prove than discrimination. But I don't know. He's got an uphill battle. This is going to be tough without, proof of it. And listen, here's where I started. When you start with, listen, I complained and I pissed everybody off, and they're celebrating me getting demoted because they hate me, that's not protected. That's not protected by any law. You have to show that I'm retaliating against you for your disability, not retaliating against you because I don't like you. Unfortunately, retaliation is harassment. Harassment should be prohibited in the workplace, but it's not necessarily actionable. It's very tough to win a harassment complaint. I don't mean sexual harassment, but a verbal harassment complaint. That's very tough to win against an employer.
Yeah, you've got to have that other component. You've got to either have race or gender or military service. There's got to be some protected class associated with it to win. Now, some employers do have a prohibition against creating a hostile work environment, and I'm not sure if CalFire does. I would suspect they do.
I'm sure they do.
But then it sort of opens the door a little bit. But I think you raise a good point, and maybe we can talk a little bit about strategy here. But when an attorney looks at a case like this, do you throw everything including the kitchen sink in the complaint, and or do you narrow your topics to avoid those avoid those types of concerns that you just raised? And because you want to make it clear, this is because of A, B, and C. It's not because of A, B, C, D, E, F, and G. It's A, B, and C.
Yeah, let me tell you what happens. Because this morning, me and Zach, and we're writing a response to an appeal. And at the main, and this is important for people to understand, at the main trial court, this is now on appeal. We won at trial, and so now they're appealing. But at trial court, the petitioner, the plaintiff, raised one issue only, just one issue. The court said, well, you only raised one issue, but I'm going to talk about that one issue plus 5 more. Right. But it's really dicta because it wasn't addressed. But the court is being very complete. You lose here. And even if you didn't lose here, you'd lose for 5 other reasons. Right. And then now we're on appeal. And in the appeal, they're appealing all those 6 things the court said. But my first point is, yeah, but you only raised one. The fact that the judge spoke about it is dicta, meaning it's not important. It wasn't the main issue. They're just being complete. Right? Trying to cause you not to appeal, but you only raised one issue. Your appeal can only be to the one issue you raised. And that, I think, if I'm the attorney, I am throwing the kitchen sink in. Just at least I raised it. I can appeal it later, but at least it's preserved for review. And that's the language we use. So I'm okay with raising everything, but I would have raised FMLA. I would have raised disability discrimination. I would have raised everything I possibly could.
All right. Well, there were 2 other cases that we didn't. One just about an update on the FDNY case.
Very interesting interview.
Yeah, and it involved an interview of some of the chiefs who were involved in litigation against FDNY Commissioner Laura Kavanaugh. I understand additional plaintiffs now have joined that lawsuit. There's actually 2 lawsuits, and I was a little disappointed in the newscaster from Fox 5, where she tried to say that because the judge didn't grant their request for a temporary restraining order or preliminary injunction, that somehow it was invalid. Yeah, that's really, and the firefighters didn't challenge that. I'm sure the attorney was probably wanting to come out of his seat, but there's 2 separate lawsuits with 2 separate sets of issues. So just because you didn't get a temporary restraining order in one doesn't mean all of your arguments in both lawsuits are going to fail. So again, we've said before, it's a tough case. We're not going to see much out of this for a while, but it's still going. It's still going.
Yeah. And again, I know people who resigned in very, very high positions from the FDNY because they wanted to avoid this commissioner. This is not like the past commissioner, right? Negro was a fire chief and came through the ranks. It's an outsider. Some people will argue, well, the outsiders, we've talked about this, have better views because they're not so ingrained in the system. They get to take a much broader view. But I think it's going to be hard for them to come up with a reason. Why did you make these decisions affecting 11 out of 16 chiefs who happen to be older, more experienced chiefs? Why? And, I just think it's a tough issue, but this is a big shakeup in the FDNY. Yeah. No question. And it's bad for morale. It's bad for everything because you're thinking, well, why do I want to be promoted? Why do I want to move up? I mean, shit, if I'm a captain and looking at a chief, battalion chief level exam, I'm thinking, no way am I moving out of here. So, but great interview. I thought the interview was interesting, and there's a lot more that's going on behind the scenes with that one.
Yeah, this past week there's been a lot of cases. Some of them I'll try to get them out this week, but last week just seems like there was a lot of different cases that are certainly worth discussing. I don't know if you want to get into some of those or.
We can. I mean, we're at only 30 minutes, but
yeah. So let's. One of them involved you, and it involved, I think it was the North Amityville Fire Department. There's been some allegations of financial irregularities, and again, I didn't blog about this case. There's quite a bit in the news, and we cover a lot of cases involving theft from volunteer fire departments. This case didn't.
This wasn't fraud. This was abuse. Yeah. So
but this carelessness when it comes to spending the taxpayers' money.
Yeah. And so the short of what it was now, I start with, as I've told the news repeatedly this week, this was a audit by the state comptroller, probably on a complaint. but it was against the board of directors from 2017 and 18. I start with, look, the membership, this new organization, same corporation, but different leadership, the membership of this organization this year and last year ousted that board, and they hired me to oust that board. It was not easy. It took a lot. They got a lawyer, but we got them ousted. And then the results of the controller's audit comes out that there were improper expenditures, not fraud, theft, but blatantly improper expenditures that should have been caught on audit, that if they're right, but
did I see the number correctly? I know one of the articles said it's somewhere around $500,000 inappropriate, or is it actually less than that?
Yeah, and I should say it's questionably inappropriate. So it's about 300,000. I think they have a $3 million or so budget, but it's about 300,000. But here's the thing: some of those were not necessarily non-legitimate. Some were, but there's questions. So, for example, and we haven't yet looked into this, but there's a lot of money, $1,500 or whatever spent on gold rings. Okay, well, to the public, that may look bad, but to an outgoing chief, right? Look, $1,500 probably shouldn't be spent, but maybe some portion of that was legitimate, so maybe some not.
Retirement type of memorial memorabilia, yeah.
Right, but other things were blatantly abusive, such as a trip to a nude resort in Jamaica. Right? Definitely should not have been paid for. Repairs to personal vehicles. Yes, maybe they were the chief's vehicles that they used to respond to a call, maybe, but there's no possible basis for paying to repairs for personal vehicles. So it looks very abusive. We could have maybe explained some of it away, but it was tough. But here's the point. We agree that those expenditures never should have been made. They wouldn't share them with us. Here's where this takes an interesting turn, and stay tuned, because we sued the accountant. The accountant did an audit, and I'm using that term audit, and he does an audit. His letter says, I'm doing an audit, and he says it 6 times. An audit has to be performed in accordance with very strict standards, which he said I will do. So we have now sued the auditor for, I could have gone back 30 years, but we went back for the last 6 years to say you looked at all of this and you didn't catch it. And he said, oh, no, I was just doing financial reports. Well, wait a minute. The membership was relying on the fact that they hired an auditor to do an audit. You give a audit letter response, and now look what happened. This is what you were supposed to stop. That's the point of an audit, to catch improper expenditures. So I don't blame the present membership at all. I blame the board of directors. And let's assume for the moment that what they thought was doing was appropriate, which is why I say, well, maybe there's some apparently legitimate belief, right? So maybe they thought that sending someone to a nude resort was somehow appropriate. Who knows, right? Maybe it's a reward, and you work so hard, we're rewarding you by sending you and your wife there. But even so, that's the point of the auditor. Right, to say you can't do that. That is not appropriate to do. And they look at internal controls. And had the auditor done the internal control review, which is point of an audit, the auditor would have caught it. So that's where we are now in court. We just sued it. We have a motion to dismiss, of course, pending. They're trying to get rid of the suit for a lot of reasons I won't get into. But I want to use North Amityville for a reason. Now, first of all, kudos to all the present members. The present members did the right thing. They recognized there's a problem. Took them years because the auditor wasn't pointing it out to them, but they realized things aren't going right. They spent a lot of time and money to oust the board, all right? And they put in a new board where we now have full financial controls and practices and much better practices. But if everybody's thinking fox and hen house, that's what you should be thinking. And that's why your internal audit committee, whether you're a little organization or a bigger organization, but most of this applies to the smaller fire departments, your audit procedure, internal audit, where your members are looking at these things, they can't be people who write the checks, right? You can't be fox and hen house. You need somebody who doesn't receive money and doesn't write the checks or incur expenses. Bring in somebody from the community. Anybody else but the people benefiting should not be doing the review. That's right. What I urge you to take from this. Now, they did that. They had an auditor who they thought was doing that. Unfortunately, here it didn't work. But get somebody who's neutral, who doesn't benefit, to be your internal auditor. So that's North Amityville.
All right. Well, there's several other cases, but I think we're up to about 40 minutes here. So I think we'll wrap it up, and I'll be adding some additional cases certainly this week. Just seems like the last week it's just been a ton of interesting lawsuits and decisions coming down. So. All right. Well, that's going to do it for another edition of Fire Law Roundup, and we'll see you again next week.